the fellow that lost his legs, was, used to be around here, and I learned from him very much. Can't remember his name. He lost one of his legs, didn't he? I think he lost a leg. Yeah. Ryan something. Do you have a number for Joe? I'd like to check up on him, see how he's okay.
I don't.
I used to, I don't know what I did.
I don't expect to be here till 3.
You think he's in good shape? That's great.
Mr. Hoover.
Yes. Thank you, Judge. So now that the state's rested, I have 3 motions for judgment of acquittal. In regards, count 1, the criminal trespass in the 2nd degree. Defense moves for judgment of acquittal in that, insofar as the state has not established or presented sufficient evidence to allow a reasonable fact finder to find beyond a reasonable doubt that Mr. Davis was lawfully directed to leave the premises. I may circle back to that. The next motion has to do with count 2, criminal mischief in the 2nd degree. And that it's alleged that he damaged property. It's the defense's position that the state has not presented sufficient evidence to allow the jury to find, beyond a reasonable doubt, that there was actually damage to the property. The jury instructions that I just emailed to the court, which I've submitted for filing with the court, I did include an extra instruction on damage, and I believe the state may have submitted one as well. But in any event, the testimony was that janitorial services. Yeah.
Sorry, let me just clarify though, the instruction that you submitted, I took to apply to 3rd degree criminal mischief rather than 2nd degree, but let me know if I'm wrong about that.
I may be confusing it with the state's requested instruction.
Okay, and I did understand the state's requested instruction to apply to 2nd degree criminal mischief. Okay. Sorry to interrupt, I just wanted to make sure I wasn't missing it.
Yes, okay, so maybe that's not in our instruction, but I would submit that there is insufficient evidence to establish to the required degree that there was actually damage to the property. The testimony was there was blood on the wall. The condition, nobody can say that the condition now or after it was cleaned up was any different than it was before. Apparently, some janitorial services cleaned it up. That's all the evidence that there was about that. Counsel submitted an instruction saying that the state doesn't need to prove economic damages, but I'd submit that there's no economic damages, there's no damages, because it was simply the same as it was before, or nobody can say otherwise. Now my 3rd motion has to do with the count 3, criminal mischief in the 3rd degree. And in this one, defense submits that there's insufficient evidence to allow the jury to find that that Mr. Davis tampered or interfered with the property. In my amended instructions, my proposed instruction number 5 discusses tampering with property, citing State v. Lee and State v. Schoen. State v. Lee, which is the more recent case from 2015, cites Schoen and kind of elaborates on that one. And it states that to tamper requires conduct that alters, rearranges, or changes property in a way that has an adverse effect on the property or its use. In my requested instruction, I added tamper or interfere. So I added interfere, but that is based on the discussion in that case about what tamper means, and tamper means to interfere. That's what the definition. The reason and I would submit that it doesn't, that the opinion doesn't say to tamper or interfere means alter, rearrange, or change the property in a way that has an adverse effects, is simply because that wasn't an issue in the case that was before the court on appeal, because the charge was simply for tampering. But in essence, reading the opinion, it's clear that tamper means interfere. So.
And does the adverse effect have to be permanent, or can it be temporary?
Well, I would submit it has to be permanent, but is that supported by Lee or Schoen? I would have to take a closer look.
Okay.
Let's see. So, yeah, in sum, those are our motions. Thank you.
And let me just ask you to expand a little bit on your views on the lack of evidence or insufficient evidence about the correction to be being lawful. I'm assuming that maybe that intersects with the constitutional argument.
Yes. That's right, Judge. So, so the state has to, for the criminal trespass in the second degree, the state has to prove that that Mr. Davis was lawfully directed to leave the premises. So, lawfully directed means that the person who gave the order had authority to give that order, but it also means that the order itself complied with state and federal constitution. And so in this case, Mr. Davis has a constitutional right to assemble under Article 1, Section 26, memory serves, and under the federal constitution, under the 5th and 14th Amendment. As well as at play is Article 1, Section 8, free speech rights. So.
Thank you, Mr. Miller. And Mr. Sullivan, yes.
Yeah. If it's all right with the court, I think there's a little bit more for us to discuss on the criminal trespass. We start with the 2 and 3 points. So Judge, I did, in the instructions I provided, did provide a definition of property damage that comes from State v. Jones. There was a tiny bit of paraphrasing, so I'd like to distribute the case and kind of point that out to the court, as I think it's relevant, of course, not just for this motion, but is relevant as to the jury instruction as well. And I'll pass a copy to the defense as well. Oh wait, can I have that copy actually? I have it apart. And I'll give and I'll point out the portion that I believe the definitions that I include in the instruction come from, but very, very briefly about the facts is that this is an old facility that's being scrapped, and there's lots of metal and pipes inside, and you're aware of this case. This is relatively new. I don't need to go on about it in that case, but in short, there was no decrease in value to the pipe that was broken, but it was still considered damage. It was still considered damage. On page 3 of 5, meaning the top right-hand corner page numbers, the first paragraph is where that component about property damage, meaning loss of completeness, efficiency, or function. And I'm not sure if the court wants to take a look at that before I go on, but I'm talking.
Point me out on page
So,
3 what it is.
so it's the paragraph that starts with, but the argument does not necessarily follow, that first full paragraph.
Just read that.
Sure.
Sense of being physically harmed or losing completeness, efficiency, or function. Okay, I see it. All right.
Okay. So it's the state's contention, obviously, with this being current law, that there is no requirement of a decrease in economic value, and in addition, the loss of completeness, efficiency, and function, we only need one of them, but all three are present here. There's testimony for the jury to consider that the wall as a whole is a piece of art. Art's function is to be looked at, studied, and visualized. In this instance, the function of it was diminished, and the completeness of the art was diminished because it was damaged. It was edited by Mr. Davis. And Mr. Gilbert has made the contention that no one can say the condition now is any different than it was before, and that it's the same as it was before. But that has no legal significance whatsoever, any more than you could intentionally dent someone's car, and the fact that a mechanic can pop that dent out doesn't mean that it wasn't damaged. We don't measure whether damage exists by what happened after the repair. We measure it by what the defendant's conduct caused. The fact that City Hall janitor was later able to fix the damage does not mean that at the time Mr. Davis painted his blood on the wall, the function of the wall as art was diminished, and in fact it was. Now I could contend to you that there were cleaning supplies involved that cost some nominal amount of money and some cost of the janitor's services, but that would largely be irrelevant because there's no need to prove that economic damages element. Its function as art has been diminished.
What all is the evidence of that? So we've got the fact that there's blood on the wall. We've got testimony that a janitor had to clean it up. What else is there, if anything else?
The photographs and video that shows the artwork was altered. That is the damage. Its functionality was altered because the art was changed by blood being added to it. So we really don't even need any evidence of cleanup efforts or what those efforts were.
You may not need it, but, well, I guess that's open to argument, but you have it. You've got evidence that a janitor had to clean it up. So I guess what I'm wanting to make sure that I'm doing is taking sort of a complete inventory of all of the state's evidence on this element, even if it is evidence that you don't necessarily think that you need.
Sure.
So what I'm seeing in that inventory is testimony that a janitor had to clean it up. And then, yes, there are pictures and video of blood on the artwork and on the wall, but I guess I'm sort of keeping that all in one category. There's blood on the artwork. So those are the two different pieces of evidence that I'm seeing so far
Correct.
that go to that element. Are there any more?
No.
Okay.
There's no more. As to criminal mischief 3, to the extent that there is a question about damage, I think that, which of course I do believe falls on the side of the state, at least for the jury to hear or to make a decision on. I think criminal mischief 3 is a little bit more clear cut because there's not that damage requirement. the property, the artwork was in fact altered, and it was a inconvenience to physically clean that, regardless of whether there's damage or not. I think that one is more clear. I do have to say that I have not had an opportunity whatsoever to review the cases that Mr. Gilbert cited for his definition of tamper. From listening to his description, it sounds like some that may not even have been defining the criminal mischief 3 statute.
So, and I'm getting where you are deriving your definition of damage for criminal mischief 2 from Jones.
Mhm.
If